Hello Mom, I'm here to represent the applicant in their application for judicial review against the respondent, Gladbury District Council. I will assume that you have read the documents filed with the court, however I will summarise the facts. The applicant is the Amphibian Protection Group, also known as APG. Now they are a pressure group with over 20 years of experience, and their aim is to run national campaigns and advise the local government on the protection of endangered species, specifically frogs and toads in the UK. Now, Gladbury District Council, the respondent, obtained a power through an Act of Parliament which is called the Cycle Superhighway Act. Now, the aim of this act was to reduce the use of motor vehicles and make cycling the natural form of transport. Now, the applicant has no issue with the act itself, rather the decision of where the respondent placed this cycle superhighway. So the applicant originally submitted an application for judicial review which was rejected. However, the court allowed the application to be reopened with oral submissions from the applicant and written submissions from the respondent. Now, it's the applicant's case that the area in which the cycle superhighway goes through is an area of farmland where the British brown toad lives. Now, the British brown toad itself has reduced in population by at least 75% over the past 100 years and only exists in 3 areas of the UK, one of which being in Gladbury. Now, where the cycle superhighway passes through and where it will be busiest is during rush hour, which coincidentally coincides with the natural migration patterns of the British brown toad, therefore exposing this British brown toad to a serious threat to life. And the applicant wishes for the judiciary to review the respondent's decision-making process in deciding to place the cycle superhighway in this farmland rather than anywhere else. Now, the respondent refutes the applicant's application for judicial review on the basis that the decision is not amenable for review, that the applicant doesn't have standing in the case, and that in any event there is an ouster clause which completely prevents the applicant seeking a judicial review of the decision. Now, the applicant completely refutes all of those points, and I'll go on to explain those further. Firstly, what I will do is outline the specific areas of law that you need to satisfy in order to be successful in bringing an application for judicial review. Now, judicial review as a concept, it is every citizen's right to be able to bring a decision forward for judicial review, and to prevent someone from doing that would be a breach of the rule of law. Now, judicial review is a process whereby the judiciary review the process taken in coming to a decision rather than the actual decision itself. And there are 5 things that need to be satisfied and considered when allowing or disallowing an application for judicial review. So the first being amenability, the second being procedural exclusivity, standing, time limits and ouster clauses. Now, considering the respondent has only raised 3 issues, amenability, standing and ouster clauses, I will focus on those in greater detail, however I will outline each principle. So, the basic principle of amenability is whether or not a decision is suitable for review. Now, the historic view of the courts was that if a decision-making power came from statute, then it was amenable, no ifs or buts. However, following sort of review of this decision, it was found that this eliminated a number of applicants in bringing a judicial review where they should have been able to, and this was evidenced in ex parte data fin and ex parte insurance services plc, where it was found that if a company or a body is performing public law services, or if the area in which they are looking to have reviewed is governed independently rather than by government, but had it not been governed independently, it may have been governed by government, then they are both instances in which they would be amenable for judicial review. Now, procedural exclusivity essentially means, and was established in O'Reilly and Macman, that only public law decisions can be amenable for judicial review. Any private matters should be done so by civil actions, and failure to do so would be an abusive process. Now, standing is a very important position, as you must be able to satisfy that the person or body bringing the action has locus standi, i.e. the right or capacity to bring an action. Now, Section 31(1) of the Senior Court Acts 1981 states that in order to bring an application for judicial review, the court shall not grant leave unless it considers the applicant has sufficient interest in the matter to which the application relates. And this was further supported in the case of Fleet Street Casuals, and a two-stage test was established. Now, standing must be considered at all phases of the application, but specifically at the permission stage, so the ex-parte stage, which we have already passed, and at the inter-party stage, so where both parties' disputes are aired. Now, when standing is considered, it's important to also consider different types of groups that may have interest in the matter at hand. So you have associations, pressure groups, individuals or interest groups. As the applicant is a pressure group, this is the area of law that I will specifically focus on. So, for the avoidance of doubt, a pressure group is a group that tries to influence the government's actions of public interest, in the interest of a specific cause. So in this case, the applicant's specific cause is the protection of endangered species, specifically brown toads and frogs. Now, this was further supported in the case of ex parte Greenpeace, whereby Greenpeace wanted to bring an application for judicial review. The respondent held that they didn't have standing as they were so far removed from the case. However, the judiciary held that the applicant, Greenpeace, had national and international presence, they had a genuine concern for the environment, i.e. the issue at hand. There were 2,500 people in support of the cause, and without the application having been brought by Greenpeace, it may not have been brought at all, or if it had have been brought, it may have been done so by an individual or a group of individuals with less experience and expertise, and it may not have been done so successfully, whereas Greenpeace have more resources and could bring it successfully. Now, time limits. They are outlined within CPR Part 54.51, and it simply states that a claim must be filed either promptly or in any event no later than 3 months after the action arose. Now, the court do have discretion in relation to this, but I won't go into it any further, considering the fact that this isn't an issue. Now, the next and final consideration are ouster clauses. You have total ouster clauses and partial ouster clauses, and partial ouster clauses mostly relate in relation to time limits. So I will focus on total ouster clauses, as that is what the respondent is stating that is within the statute and are barring the applicant from bringing this claim. Now, total ouster clauses are inherently rejected by the court, and the court view them in quite a hostile manner, because to include a total ouster clause within a statute to prevent anyone from bringing a claim for judicial review would be a complete breach of the rule of law, as the judiciary wouldn't be able to hold the executive or the legislature to questioning and be able to explain how they came to their decisions. Now, moving on to the specific areas of law and why we believe that the applicant should be successful in this claim for judicial review. Amenability is a simple concept, and it's simple in this circumstance because the respondent obtained their powers through statute, the Cycle Superhighway Act, and the historical view of the courts in amenability is that if a power is granted through an act of Parliament, then it is amenable for judicial review because it clearly has a function in public law and has a national interest. Now, in any event, it will be amenable for judicial review as per ex parte data fin, as it's a matter of national interest because their decision could result in the extinction or the promotion of the extinction of this animal. Therefore, it's likely that a number of individuals would be interested or feel passionately about this matter. Now, in relation to standing, the applicant wishes to rely heavily on the case of ex parte Greenpeace as the circumstances are extremely similar. Now, as explained before, we must prove that the applicant has locus standi and sufficient interest in the matter. Now, despite the initial application being rejected on the face of it, the court did not provide any reasons for this. Therefore, it cannot be assumed that it was rejected on the basis of standing. There are a number of other issues, as I've already explained, that could mean the application was rejected. Now, the applicant is a pressure group, which we've already established. It has 20 years of experience, it has a specific interest, and runs a cause in relation to the protection of endangered species, and even advises the government on the protection of the same. So in the passing of this act, one would assume that they would have been consulted when making this decision as to where to place this cycle superhighway. And when considering the 4 factors established in Greenpeace, that they are a national pressure group with significant backing, their experience in the field, and should this application fail, should it be found that they don't have standing, an individual or a group of individuals may have to bring this claim and might do so unsuccessfully because they lack the knowledge and the resources in order to bring it successfully. And this can be shown through the significant research done by the applicant in finding that the British brown toad's population has been reduced by 75% and that they exist in only 3 parts of the country. Now, the total ouster clause within the Act states that any person or body shall not be subject to appeal or be liable to be questioned in any court. Now, as already mentioned, historically the courts are hostile to these total ouster clauses, as they are deemed unconstitutional to the general public's right to bring a claim for judicial review. Therefore, I do not see why it would be reasonable for the court to stray from this perspective now, as there is no significant or compelling reason to do so. Now, to conclude, the applicant refutes successfully all of the points that the respondent makes in relation to the reasons why the applicant should not be successful. Therefore, I would invite the court to allow this application and to review the decision of Gladbury District Council. Again, all we wish to do is for the judiciary to review the decision-making process that Gladbury District Council have followed. Now, if you have any further questions, please don't hesitate to ask. Thank you.